MN Real Estate Exam Practice Questions. Question 1. Why would an appraiser rely heavily on the cost approach for a newly built condominium unit in Bloomington? Option A. Replacement cost and depreciation can be estimated more reliably for new improvements. Option B. It ignores land value completely. Option C. It is the only legal method for all residential property. Option D. It values the property only by monthly rent. The correct answer is option A. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 2. Two investors own a Bloomington duplex with unequal shares and no survivorship language. Which ownership form is most likely? Option A. Tenancy by the entirety. Option B. Tenancy in common. Option C. Severalty. Option D. Life tenancy only. The correct answer is option B. Tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 3. A residential buyer has not signed a representation contract. How should the licensee describe the buyer's status after agency disclosure for Harper & Moorhead involving a fourplex priced at $453,500? Option A. The buyer is automatically a client forever. Option B. The buyer becomes the broker's employee. Option C. The buyer is a customer unless and until a written representation contract is signed. Option D. The buyer receives ownership rights in the brokerage. The correct answer is option C. The buyer is a customer unless and until a written representation contract is signed. Minnesota agency disclosure explains that a consumer is not represented until a written representation contract is signed. Customer status is different from client representation. Employment and ownership rights are not created by receiving agency disclosure. Question 4. Recording a deed for a farm parcel in Rice County primarily gives what type of notice to the public? Option A. Private notice only to the buyer's lender. Option B. A zoning variance. Option C. A guarantee of physical condition. Option D. Constructive notice. The correct answer is option D. Constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 5. A Edina parcel contains 9 acres. How many square feet are in the parcel? Option A. 392,040. Option B. $36,800. Option C. $250,200. Option D. $4,003. The correct answer is option A. 392,040. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 6. Which fiduciary duty requires a broker to follow a client's lawful directions for Casey and Stillwater involving a farm parcel priced at $434,000? Option A is cheat. Option B, obedience. Option C, novation. Option D, subordination. The correct answer is option B, obedience. Obedience requires following lawful client instructions. It does not require obeying illegal instructions or ignoring disclosure duties. Is cheat, novation, and subordination are unrelated legal concepts. Question 7. If a seller rejects Avery Patel's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. At the end of the listing period. Option C. no later than the next business day after rejection. Option D, after the broker deducts marketing expenses. The correct answer is option C, no later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 8. A neighbor receives permission to park on Skylar Okafor's land for 1 weekend only. What interest is most likely created? Option A, easement appurtenant. Option B, fee simple estate. Option C, a mechanic's lien. Option D, license. The correct answer is option D, license. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land, fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license. Question 9. A Minnesota salesperson renewal fee includes a contribution to which fund for Finley in Bemidji involving a vacant lot priced at $285,000? Option A, Real Estate Education, Research and Recovery Fund. Option B, Federal Flood Insurance Reserve. Option C, County Recording Technology Fund only. Option D, Private MLS Scholarship Account. The correct answer is option A, Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 10. A rental property produces $55,500 in net operating income and investors require a 7.5% capitalization rate. What value is indicated by the income approach? Option A, $186,875. Option B, $740,000. Option C, $238,700. Option D, $14,450. The correct answer is option B, $740,000. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 11. At Granite Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers for Hayden and Rochester involving a newly built townhouse priced at $379,500. Option A, MLS Grid. Option B, Torrens Online. Option C, Pulse. Option D, HUD Exchange. The correct answer is option C, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 12. An easement benefits a neighboring parcel by allowing driveway access across Reese Nolan's land. What type of easement is most likely? Option A, personal license only. Option B, trade fixture. Option C, a mechanic's lien. Option D, easement appurtenant. The correct answer is option D, easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 13. A zoning board permits a property use that otherwise violates strict zoning because of unique hardship. What relief is typically granted for Sawyer in St. Paul involving a fourplex priced at $261,500? Option A, variance. Option B, certificate of title. Option C, quitclaim covenant. Option D, mortgage assumption. The correct answer is option A, variance. A variance provides relief from strict zoning requirements when legal standards are met, often involving unique hardship. Certificates of title, quitclaim deeds, and mortgage assumptions do not authorize zoning deviations. Land use approval is the issue. Question 14. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Riley and Red Wing involving a mixed-use property priced at $230,000? Option A. It is always protected opinion regardless of knowledge. Option B. It is a factual misrepresentation about a material property condition. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option B. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 15. A buyer includes an inspection condition in a St. Cloud purchase agreement. What is the role of that contingency for Cameron in St. Cloud involving a rental house priced at $296,000? Option A. It automatically transfers title to the buyer. Option B. It eliminates the need for earnest money accounting. Option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option D. It makes the broker a home inspector. The correct answer is option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 16. A landlord in Winona deducts from a security deposit for unpaid rent and damage beyond ordinary wear and tear. What makes those deductions more defensible for Kendall in Winona involving a small retail building priced at $460,000? Option A. They are based only on the landlord's dislike of the tenant. Option B. They include normal fading of paint from ordinary use. Option C. They are taken without notice because deposits are always non-refundable. Option D. They are tied to permitted reasons and supported by a written explanation. The correct answer is option D. They are tied to permitted reasons and supported by a written explanation. Minnesota security deposit deductions are generally tied to unpaid obligations or damage beyond ordinary wear and tear, with a written explanation when money is withheld. Personal dislike, normal wear, and treating every deposit as non-refundable are not defensible bases. Documentation is essential in landlord-tenant accounting. Question 17. If assessed value is $266,400 and the tax rate is 18 mils, what is the annual property tax? Option A, $4,795. Option B, $1,310. Option C, $7,548. Option D, $44,400. The correct answer is option A, $4,795. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 18. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Kendall in Winona involving a small retail building priced at $284,500? Option A, personal income withholding tax. Option B, mortgage registry tax. Option C, sales tax on furniture. Option D, special assessment appeal fee. The correct answer is option B, mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 19. A parcel borders a non-navigable stream. rights connected to that water are commonly called what for Reese in Minneapolis involving a lake cabin priced at $225,500? Option A, literal rights only. Option B, emblement rights. Option C, riparian rights. Option D is subrogation rights. The correct answer is option C, riparian rights. Riparian rights relate to land adjoining rivers or streams. Literal rights are associated with lakes and other large bodies of water, while emblements and subrogation are different concepts. Water-adjacent property rights are common ownership questions. Question 20. If Sawyer fails to complete required continuing education by the renewal deadline, what license consequence can occur? Option A. The license automatically converts to a broker license. Option B. The license becomes a deed restriction. Option C. The license renews for free without further action. Option D. The license can become inactive. The correct answer is option D. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 21. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Taylor in Maple Grove involving a rental house priced at $320,000? Option A. To allocate income or expenses to the party who owned the property during the relevant time period. Option B. To change the sales price after acceptance. Option C. To avoid recording the deed. Option D. To eliminate the need for title insurance. The correct answer is option A. To allocate income or expenses to the party who owned the property during the relevant time period. Priorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 22. A buyer asks whether a nursing home in the neighborhood must be disclosed as a material fact. How does Minnesota treat that issue for Skylar in Eagan involving a newly built townhouse priced at $311,000? Option A. It is always a material defect in the property. Option B. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Option C. It requires a separate appraisal license. Option D. It makes the deed void. The correct answer is option B. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Minnesota law excludes certain neighborhood-related facilities, including nursing homes, from material fact treatment merely because they are nearby. This does not remove duties to disclose physical defects or known material facts. Appraisal licensing and deed validity are unrelated. Question 23. A licensee directs families with children only toward one area of Minneapolis. What fair housing problem does that conduct create for Reese in Minneapolis involving a single-family home priced at $455,000? Option A. Amortization. Option B. Subordination. Option C. Steering. Option D. Novation. The correct answer is option C. Steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 24. What is the main purpose of an owner's title insurance policy for Avery Okafor? Option A. To insure the roof against storm damage. Option B. To guarantee future market appreciation. Option C. To replace the need for a purchase agreement. Option D. To protect against covered title defects that existed before the policy date. The correct answer is option D. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 25. A Bloomington salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper? Option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option B. Personal funds must always be kept in the listing broker's trust account. Option C. Salespersons may use trust accounts as savings accounts with broker consent. Option D. Commingling is allowed when the amount is less than 1 month's rent. The correct answer is option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 26. A homestead classification question appears on a Minnesota practice exam. What topic is being tested most directly for Avery in Northfield involving a duplex priced at $378,000? Option A. Federal lead paint pamphlet rules only. Option B. Property tax and ownership status treatment. Option C. Advertising font size only. Option D. Dual agency consent wording only. The correct answer is option B. Property tax and ownership status treatment. Homestead classification generally relates to property tax and ownership or occupancy status. Lead paint, advertising, and dual agency are separate real estate topics. Exam questions may connect homestead status with tax treatment and ownership rights. Question 27. A Granite Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable for Skylar in Eagan involving a newly built townhouse priced at $296,500? Option A. No, only a paper binder signed by every buyer is allowed. Option B. Yes, but only if clients pay a records fee. Option C. Yes, access to required statutes and rules may be made available electronically. Option D. No, statutes are never required in real estate offices. The correct answer is option C. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 28. In Winona, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Kendall and Winona involving a small retail building priced at $212,500. Option A. Be at least 21, complete only course I, and work independently after passing the exam. Option B. Complete continuing education before any pre-license education and apply directly without a broker. Option C. Pass only the national exam and begin practicing while the application is pending. Option D. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. The correct answer is option D. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 29. If annual property taxes of $2,900 are prorated to the seller for 161 days on a 365-day basis, approximately what amount is charged to the seller? Option A, $1,279. Option B, $13,895. Option C, $5,062. Option D, $879. The correct answer is option A, $1,279. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 30. A lender draws a line around a Stearns neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Harper and Moorhead involving a rental house priced at $387,500? Option A, plottage. Option B, redlining. Option C, accretion. Option D, estoppel. The correct answer is option B, redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 31. If Jordan Gwynn tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A, keep the information confidential until the closing date. Option B, cancel the agreement without telling the buyer. Option C, immediately disclose the stated intent not to perform to the other party or parties. Option D, disclose only if the seller misses a loan contingency. The correct answer is option C, immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 32. A listing agreement for a Northfield seller is missing a definite end date. Why is that a licensing problem for Avery in Northfield involving a rental house priced at $432,000? Option A, listing agreements are valid only if they renew forever. Option B, expiration dates are allowed only in commercial leases. Option C, the county recorder assigns the expiration date after closing. Option D, Minnesota listing agreements must include a definite expiration date. The correct answer is option D. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 33. A facilitator working with Taylor and Moorhead performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, confidentiality. Option B, loyalty to the seller only. Option C, obedience to the buyer's investment goals. Option D, advocacy for the party paying the commission. The correct answer is option A, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 34. A property owner dies with no will and no heirs. What government power may transfer the property to the state for Sawyer in St. Paul involving a duplex priced at $379,000? Option A, eminent domain. Option B, this cheat. Option C, literal rights. Option D, subordination. The correct answer is option B, escheat. Escheat transfers property to the state when an owner dies without a will and without heirs. Eminent domain involves compensated taking, literal rights involve water, and subordination changes lien priority. The absence of heirs is the clue. Question 35. A parcel borders a lake near Northfield. Rights associated with use of the lake shore are commonly called what for Avery in Northfield involving a rental house priced at $412,500? Option A, riparian rights only. Option B, fixture rights. Option C, literal rights. Option D, novation rights. The correct answer is option C, literal rights. Literal rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams. Fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 36. Before negotiating a purchase involving a licensee's sibling as a principal, what should the licensee do for Quinn and Eden Prairie involving a farm parcel priced at $208,500? Option A, say nothing because relatives are not licensees. Option B, disclose only after the commission is paid. Option C, ask the lender to disclose it instead. Option D, disclose the relationship in writing before negotiating or consummating the transaction. The correct answer is option D, disclose the relationship in writing before negotiating or consummating the transaction. Minnesota requires written disclosure when a principal is a licensee's relative or business associate. Waiting until after commission payment is too late, and the duty is not shifted to the lender. The rule protects parties from undisclosed conflicts of interest. Question 37. A deed is signed by the grantor but never delivered to Harper Anderson. Why is delivery important? Option A, delivery shows the grantor's intent that the deed take effect. Option B, delivery sets the mortgage interest rate. Option C, delivery replaces legal description requirements. Option D, delivery creates a leasehold only. The correct answer is option A. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 38. A licensee in Bloomington wants to know which required continuing education topics must be included in the renewal cycle along with the general module. Option A, only appraisal theory and mortgage underwriting. Option B, agency law and fair housing. Option C, only property insurance and income tax preparation. Option D, only construction codes and zoning administration. The correct answer is option B, agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 39. Which deed gives Harper Anderson the broadest set of title warranties from the grantor? Option A, quitclaim deed. Option B, bargain and sale deed with no covenants. Option C, general warranty deed. Option D, tax certificate only. The correct answer is option C, general warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 40. For Cameron Okafor's first real estate job in St. Cloud, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A, the applicant directly through a personal account only. Option B, the listing client from the applicant's first transaction. Option C, the county recorder in the county where the applicant lives. Option D, the licensed real estate broker with whom the applicant is associated. The correct answer is option D, the licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 41. A legal description refers to township, range, and section. Which survey system is being used for Quinn and Eden Prairie involving a farm parcel priced at $244,000? Option A, rectangular government survey system. Option B, meets and bounds only. Option C, lot and block only. Option D, a gross lease system. The correct answer is option A. Rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 42. A broker tells competing firms to keep commissions at the same percentage in Bemidji. What legal risk is most obvious? Option A. Accretion. Option B. Price fixing under antitrust law. Option C. Constructive eviction. Option D. Functional obsolescence. The correct answer is option B. Price fixing under antitrust law. Competitors agreeing on commission rates can be price fixing, an antitrust violation. Accretion, constructive eviction, and functional obsolescence involve land change, landlord-tenant issues, and valuation. Commissions must be independently negotiated, not fixed by competitors. Question 43. Why should a purchase agreement for a vacant lot in Bemidji be in writing and signed by the party to be charged? Option A. All oral contracts are criminal offenses. Option B. Only lenders may sign real estate contracts. Option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option C. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 44. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for lease in Minneapolis involving a single-family home priced at $222,500? Option A. Keep the entire deposit automatically as a cleaning fee. Option B. Apply the deposit to the broker's commission. Option C. Record the deposit with the county as a deed restriction. Option D. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. The correct answer is option D. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 45. If an override clause appears in Kendall Miller's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A. A protective list. Option B. A new deed. Option C. A county tax appeal. Option D. A mortgage payoff statement. The correct answer is option A. A protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 46. During negotiations in Edina, Jordan Garcia changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is an acceptance because some terms stayed the same. Option B. It is a counteroffer that rejects the original offer and proposes new terms. Option C. It creates a lease instead of a purchase contract. Option D. It keeps the original offer open forever. The correct answer is option B. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 47. Why is the Minnesota agency disclosure form given to Reese Miller not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It replaces all purchase agreement requirements. Option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option D. It gives the consumer a license to sell property. The correct answer is option C. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 48. Before advertising Kendall Anderson's vacant lot to the general public, what must a Minnesota licensee obtain? Option A. An oral promise that the owner may list later. Option B. A buyer's pre-approval letter. Option C. A tax parcel map from the county. Option D. A signed listing agreement or other signed written authorization from the owner or authorized person. The correct answer is option D. A signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 49. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Morgan and Brainerd involving a townhome priced at $465,000? Option A. Compensation is determined between each individual broker and the broker's client. Option B. The state sets one mandatory commission rate for all residential listings. Option C. The MLS sets the minimum commission for every listing. Option D. The buyer must always pay the listing broker directly. The correct answer is option A. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 50. Before Riley schedules the salesperson examination after studying in Edina, which pre-license course must already be completed? Option A, Course 2 only. Option B, Course I. Option C, Course 3 only. Option D, the annual continuing education module. The correct answer is option B, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 51. A $442,500 sale carries a 6.5% commission. What is the total commission before any split? Option A, $44,250. Option B, $3,982. Option C, $28,762. Option D, $4,779. The correct answer is option C, $28,762. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 52. In a dual agency situation in Moorhead, why must the licensee avoid advocating exclusively for one party for Harper in Moorhead involving a rental house priced at $448,500? Option A. The broker becomes a government mediator. Option B. The buyer automatically becomes the broker's only client. Option C. The seller's broker relationship disappears at acceptance. Option D. The broker owes duties to both buyer and seller within the limits of dual agency. The correct answer is option D. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 53. If a Maple Grove property sells for $344,500 and the buyer obtains an 70% loan, what is the buyer's down payment? Option A, $103,350. Option B, $241,150. Option C, $21,531. Option D, $696. The correct answer is option A, $103,350. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 54. A built-in dishwasher is attached and adapted to a single-family home. What is it most likely considered in a sale for Jordan in Edina involving a single-family home priced at $318,000? Option A, emblement. Option B, fixture. Option C, trade name. Option D, license. The correct answer is option B, fixture. A fixture is personal property that has become real property through attachment, adaptation, intent, or agreement. Emblements are crops, a trade name is business identity, and a license is permission. Built-in appliances are commonly analyzed as fixtures. Question 55. A St. Paul salesperson asks whether Minnesota state law or a private study guide controls if they conflict. Which source governs? Option A. The private study guide controls if newer. Option B. A salesperson's office custom controls. Option C. Minnesota law governs the licensing issue. Option D. The buyer's preferred answer controls. The correct answer is option C. Minnesota law governs the licensing issue. Official guidance makes clear that Minnesota law governs licensing issues. Study guides and office customs are learning tools or business practices, not controlling law. A buyer's preference cannot override statutory requirements. Question 56. A city takes private land for a public road after paying just compensation. What power is being exercised for Sawyer in St. Paul involving a rental house priced at $265,000? Option A is cheat. Option B, adverse possession. Option C, police power only. Option D, eminent domain. The correct answer is option D, eminent domain. Eminent domain is the government's power to take private property for public use with just compensation. Escheat transfers property to the state when no heirs exist, and adverse possession is private acquisition through possession. Police power regulates use but does not by itself describe a compensated taking. Question 57. After passing the examination, Emerson wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying for Emerson in Duluth involving a condominium unit priced at $473,500? Option A. Courses 2 and 3 must be successfully completed if they have not already been completed. Option B. Only course I is ever required for the license. Option C. A broker's 30-hour course must replace course 3. Option D. No additional education is needed once the exam is passed. The correct answer is option A. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 58. If Rowan passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam as required for Rowan in Mankato involving a lake cabin priced at $390,000? Option A, 30 days from passing the examination. Option B, 1 year from passing the examination. Option C, 3 years from passing the examination. Option D, until the next broker renewal cycle only. The correct answer is option B, 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 59. A deed expressly creates survivorship between co-owners of a farm parcel. Which ownership feature is being emphasized for Blair in Bloomington involving a farm parcel priced at $251,000? Option A. No right to possess the property. Option B. A tenant's trade fixture right. Option C. Right of survivorship in joint tenancy. Option D. A mortgagee's foreclosure priority. The correct answer is option C. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 60. In appraisal, what does highest and best use require for Drew and Woodbury involving a mixed-use property priced at $287,000? Option A. The use that produces the highest commission. Option B. The use preferred by the current tenant only. Option C. The use with the lowest property tax bill. Option D. A use that is legally permissible, physically possible, financially feasible, and maximally productive. The correct answer is option D. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 61. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Rowan and Mankato involving a single-family home priced at $433,000? Option A. Disclose known facts that contradict the report. Option B. Stay silent because the report always controls. Option C. Destroy the report and order a new one. Option D. Tell only the inspector after closing. The correct answer is option A. Disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 62. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Drew and Woodbury involving a mixed-use property priced at $399,000? Option A. Cost approach only. Option B. Sales comparison approach. Option C. Income approach only. Option D. A front foot method only. The correct answer is option B. Sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 63. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Casey and Stillwater involving a condominium unit priced at $295,000? Option A. The salesperson may continue independently for 90 days. Option B. The salesperson automatically becomes a limited broker. Option C. The salesperson's license becomes inactive until proper association is restored. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option C. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 64. A zoning ordinance limits building height in Bemidji. What government power is most directly involved for Finley in Bemidji involving a vacant lot priced at $253,500? Option A, eminent domain. Option B, this cheat. Option C, taxation only. Option D, police power. The correct answer is option D, police power. Police power allows government to regulate property use for health, safety, morals, and general welfare. Eminent domain is taking for public use, escheat handles ownerless property, and taxation raises revenue. Zoning is a classic police power regulation. Question 65. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Casey and Stillwater involving a condominium unit priced at $212,500? Option A, highest and best use. Option B, tie-in arrangement. Option C, novation. Option D, steering. The correct answer is option A, highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 66. A social media ad for a fourplex in Moorhead uses a team name. What must the advertisement clearly and conspicuously display for Harper in Moorhead involving a fourplex priced at $468,500? Option A, only the salesperson's nickname. Option B, the real estate brokerage name. Option C, only the property street address. Option D, only the team logo without the brokerage. The correct answer is option B, the real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 67. A broker learns that a foundation defect could significantly affect Rowan Chen's use of a mixed-use property in Mankato. What should the broker do? Option A, stay silent because the defect might reduce the seller's price. Option B, disclose only after closing if the buyer complains. Option C, disclose the material fact to the prospective purchaser. Option D, treat the defect as confidential even if it affects use and enjoyment. The correct answer is option C, disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 68. When Casey Nolan buys a condominium unit in Stillwater, what does the buyer typically own? Option A, only a stock certificate and no real property interest. Option B, the entire building in Severalty. Option C, a temporary license to occupy the unit. Option D, the individual unit plus an undivided interest in the common elements. The correct answer is option D, the individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 69. During a Eden Prairie license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Quinn in Eden Prairie involving a vacant lot priced at $359,000? Option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option B, 10 hours every 4 years with no annual deadline. Option C, 30 hours only during the first licensing year. Option D, only the required module with no other continuing education. The correct answer is option A, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 70. A legal description identifies a lot and block in a recorded subdivision plat. Which description method is used for Blair in Bloomington involving a condominium unit priced at $272,500? Option A, rectangular survey only. Option B, lot and block. Option C, a monumentless description. Option D, a front foot appraisal. The correct answer is option B, lot and block. Lot and block descriptions rely on a recorded subdivision plat. Rectangular survey uses sections, townships, and ranges, while front foot appraisal values frontage. The presence of a recorded plat points to lot and block. Question 71. A city special assessment for a new sidewalk appears on a property record. What kind of charge is it most like for Sawyer in St. Paul involving a rental house priced at $228,500? Option A, a private broker commission split. Option B, a personal credit card debt. Option C, a charge against benefited property for a public improvement. Option D, a title insurance premium refund. The correct answer is option C, a charge against benefited property for a public improvement. A special assessment is commonly charged against properties that benefit from a public improvement. It is not a broker split, personal consumer debt, or title insurance refund. Assessments can affect closing and ownership costs. Question 72. Which Minnesota tax is generally associated with recording a deed that conveys real property for Blair in Bloomington involving a condominium unit priced at $327,500? Option A, mortgage registry tax only. Option B, utility franchise fee. Option C, federal gift tax return fee. Option D, state deed tax. The correct answer is option D, state deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 73. A Edina buyer's loan has small monthly payments but one large final payment. What is that final payment called for Jordan in Edina involving a single-family home priced at $448,500? Option A, balloon payment. Option B, proration credit. Option C, replacement reserve. Option D, equity dividend. The correct answer is option A, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 74. A lot has 210 front feet worth $260 per front foot. What is the indicated front foot value? Option A, $3,273. Option B, $54,600. Option C, $20,790. Option D, $1,041,667. The correct answer is option B, $54,600. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 75. A legal description begins at a point of beginning and follows distances and directions around the boundary. Which system is used for Finley in Bemidji involving a vacant lot priced at $280,500? Option A, gross rent multiplier. Option B, capitalization rate. Option C, meets and bounds. Option D, straight line depreciation. The correct answer is option C, meets and bounds. Meets and bounds descriptions trace boundaries using distances, directions, and a point of beginning. GRM, cap rate, and depreciation are valuation concepts. The boundary walking format identifies the legal description method. Question 76. A seller instructs the licensee not to disclose a known structural defect to buyers. Which principal controls for Cameron in St. Cloud involving a rental house priced at $299,000? Option A. The licensee must obey every instruction from a client. Option B. The defect becomes confidential forever. Option C. The buyer's broker alone must discover every defect. Option D. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. The correct answer is option D. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 77. Which document is used to convey ownership of real property from grantor to grantee for Finley in Bemidji involving a vacant lot priced at $392,500? Option A. Deed. Option B. Promissory note. Option C. Listing presentation. Option D. Home inspection checklist. The correct answer is option A. Deed. A deed is the instrument used to convey title from grantor to grantee. A promissory note creates a debt promise, a listing presentation markets services, and an inspection checklist reports property condition. Conveyance and financing documents have different functions. Question 78. If one broker represents both Taylor Wilson and Jordan Miller in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. All parties must give informed consent to the dual agency relationship. Option C. The broker may proceed without consent if the commission is reduced. Option D. Consent is unnecessary if two different salespersons are involved. The correct answer is option B. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 79. Which ownership estate gives Sawyer Anderson the greatest bundle of rights with no stated end date or condition? Option A. Estate at sufferance. Option B. Life estate. Option C. Fee simple absolute. Option D. License. The correct answer is option C. Fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life. An estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 80. A title search finds an unpaid mechanics lien recorded against a Minneapolis property. Why does this matter to a buyer? Option A. It proves the buyer has already paid cash. Option B. It automatically creates a condominium. Option C. It removes all property taxes. Option D. It may be an encumbrance affecting title and closing requirements. The correct answer is option D. It may be an encumbrance affecting title and closing requirements. A mechanics lien can encumber title and may need to be resolved before or at closing. It does not prove cash payment, create condominium ownership, or remove tax obligations. Title review identifies recorded claims that may affect ownership. Question 81. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Parker and Blaine involving a small retail building priced at $282,000? Option A. Amortization. Option B. Accretion. Option C. Subordination. Option D. This cheat. The correct answer is option A. Amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup, subordination changes lien priority, and escheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 82. Why might Casey Johnson use a quitclaim deed to clear a possible title issue? Option A. It guarantees the property is free of every lien. Option B. It transfers whatever interest the grantor may have without making title warranties. Option C. It creates a new mortgage automatically. Option D. It replaces the need for delivery and acceptance. The correct answer is option B. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 83. Gradual soil buildup along a stream increases a parcel's size. What term best fits for Schuyler and Egan involving a newly built townhouse priced at $314,000? Option A. Avulsion. Option B. Condemnation. Option C. Accretion. Option D. Defeasance. The correct answer is option C. Accretion. Accretion is gradual addition of land through natural forces. Avulsion is sudden change, condemnation is taking by eminent domain, and defeasance concerns loan satisfaction. Gradual buildup is the key clue. Question 84. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Parker and Blaine involving a newly built townhouse priced at $337,500? Option A. Credit score above 700. Option B. Preference for lakefront homes. Option C. Employment in real estate sales. Option D. Familial status. The correct answer is option D. Familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 85. A restaurant tenant installs removable ovens for the tenant's business. What are those items often called for Rowan in Mankato involving a mixed-use property priced at $193,500? Option A. Trade fixtures. Option B. Riparian rights. Option C. Deed restrictions. Option D. Remainders. The correct answer is option A. Trade fixtures. Trade fixtures are business-related items installed by a tenant and usually removable if removed timely and damage is repaired. Riparian rights concern water, deed restrictions limit property use, and remainders are future interests. The tenant's business equipment points to trade fixtures. Question 86. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Hayden and Rochester involving a small retail building priced at $402,500? Option A. Minnesota Statutes Chapter 287 only. Option B. Minnesota Statutes Chapter 82. Option C. The Federal Internal Revenue Code only. Option D. A local MLS policy manual only. The correct answer is option B. Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 87. A broker refuses to show listings unless a buyer also uses the broker's mortgage affiliate. What antitrust concept could be implicated for Parker and Blaine involving a newly built townhouse priced at $311,000? Option A. Accretion. Option B. Estoppel. Option C. Tie-in arrangement. Option D. Substitution principle. The correct answer is option C. Tie-in arrangement. A tie-in arrangement conditions one service on the purchase of another service and can raise antitrust concerns. Accretion, estoppel, and substitution are property or valuation concepts. Consumers should not be unlawfully forced into affiliated services. Question 88. Under Chapter 82 standards, What must a broker do to properly supervise salespersons at a St. Paul office for Sawyer in St. Paul involving a fourplex priced at $309,500? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Supervise only advertising and ignore purchase agreements. Option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. The correct answer is option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 89. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Reese in Minneapolis involving a single-family home priced at $400,500? Option A. Within 3 business days of receipt or final acceptance, whichever is later. Option B. Only after the buyer's loan is fully underwritten. Option C. At any time before the deed is recorded. Option D. Within 30 calendar days after the first showing. The correct answer is option A. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 90. A licensee in Winona drafts a complex legal clause for Kendall Rivera instead of recommending legal counsel. What risk is created? Option A. Constructive eviction. Option B. Unauthorized practice of law. Option C. Functional obsolescence. Option D. Inverse condemnation. The correct answer is option B. Unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 91. A garage built on Sawyer Chen's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A. Hypothecation. Option B. Subrogation. Option C. Encroachment. Option D. Reconciliation. The correct answer is option C. Encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt, subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 92. A licensee exaggerates by saying a backyard view is the best sunset in Minnesota. How is that usually classified for Cameron in St. Cloud involving a fourplex priced at $193,500? Option A. A guaranteed appraisal. Option B. A material title defect. Option C. A deed restriction. Option D. Puffing if it is clearly opinion rather than a factual claim. The correct answer is option D. Puffing if it is clearly opinion rather than a factual claim. Puffing is an opinion or sales statement that a reasonable person would not treat as a factual guarantee. It differs from misrepresenting a known defect or title issue. The sunset statement is subjective unless tied to a specific false fact. Question 93. A utility company has the right to run power lines across a Rochester parcel. Which property right is usually involved for Hayden in Rochester involving a newly built townhouse priced at $387,500? Option A. Easement in gross. Option B. The state for years. Option C. Divulsion. Option D. A remainder interest. The correct answer is option A. Easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 94. When Avery, a licensee, intends to buy a client's property in Maple Grove, what disclosure is required before negotiation or consummation? Option A. The licensee may stay silent if paying full market value. Option B. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. Option C. The disclosure is needed only after the deed is recorded. Option D. Only the buyer's lender must be told about the license. The correct answer is option B. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 95. A salesperson tells owners in Maple Grove to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe for Taylor in Maple Grove involving a duplex priced at $299,500? Option A. Reconciliation. Option B. Hypothecation. Option C. Blockbusting. Option D. Assemblage. The correct answer is option C. Blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 96. A deed gives Hayden possession for life, then ownership passes to Parker Peterson. What interest does Parker Peterson hold before Hayden's death? Option A. Leasehold estate. Option B. Easement in gross. Option C. Mortgage lien. Option D. A remainder interest. The correct answer is option D. Remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 97. A property use existed legally before a zoning change and may continue despite the new rule. What is it called for Blair in Bloomington involving a vacant lot priced at $256,500? Option A. Legal non-conforming use. Option B. Blockbusting. Option C. Estoppel certificate. Option D. Defeasible fee only. The correct answer is option A. Legal non-conforming use. A legal non-conforming use lawfully existed before a zoning change and is often allowed to continue under limits. Blockbusting is a fair housing violation, estoppel certificates relate to leases or representations, and defeasible fee is an ownership estate. The timing before the zoning change is key. Question 98. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Casey in Stillwater involving a farm parcel priced at $370,000? Option A. Immediate ownership and possession of the property. Option B. A lien securing repayment while the borrower retains title. Option C. A life estate measured by the borrower's life. Option D. A leasehold estate for the loan term. The correct answer is option B. A lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 99. Which fiduciary duty requires a broker to keep client money and property properly accounted for Blair in Bloomington involving a vacant lot priced at $318,500? Option A. Assemblage. Option B. Accretion. Option C. Accounting. Option D. Divulsion. The correct answer is option C. Accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and avulsion are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 100. Two brokerages agree that one will work only north of Winona and the other only south. What antitrust violation may this suggest for Kendall and Winona involving a newly built townhouse priced at $230,000? Option A, redemption. Option B, assemblage. Option C is subrogation. Option D, a market allocation. The correct answer is option D, market allocation. Market allocation occurs when competitors divide customers or territories instead of competing. Redemption, assemblage, and subrogation are unrelated real estate concepts. Geographic division by competing brokerages creates serious antitrust risk.